Scrutiny of nominations is a very technical aspect, and a very small technical lapse or a mistake on the part of the returning officer can vitiate the whole election process. If the nomination of a candidate is improperly rejected, the law says that the election will be ab initio void. Nothing else is to be proved by the defeated candidate except to prove that the nomination was not properly rejected. And then the man who has won, his election will immediately be set aside. Nothing else is to be proved. But if the nomination paper is improperly accepted, I mean it has been accepted, which in fact should have been rejected, that does not meet with that fatal consequence. In that case, the law says that the candidate who lost has to prove that the man whose nomination was improperly accepted, his votes should have come to me and would have come to me, and then my votes would have been more than the winning candidate, which is almost very difficult. So our advice always from the election commissions is that you err on the right side. Unless you are 100% sure about the nomination paper of a candidate is not proper, I mean that needs to be rejected on some very special grounds, then only you go for that. Otherwise you give the benefit of doubt, as they say in cricket, the benefit of doubt should go to the batsman. Similarly, here also our batsman is the candidate, and you give the benefit of doubt to him, let him contest, and then ultimately the voters will decide. But this does not mean that even where you are satisfied that the nomination ought to be rejected, you still say okay, you just contest. That is not there. But at the same time you must be very sure about the ground of rejection. And the scrutiny of nominations is a quasi-judicial function. The returning officer plays a very crucial role, and the law says, and the Supreme Court has also upheld, that it's a quasi-judicial function, and in the performance of this function the returning officer has to apply his independent mind. He cannot be guided by any senior officers or even by the election commission's officers that you do like this or don't do like this. You have to, of course you have to apply your mind, you have to see that all the instructions, directions, all the provisions of the law are fulfilled. If any clarification has been given by the election commission, you keep that in mind. If any decision of the Supreme Court or the High Courts have been rendered on that point, you have to keep that in that mind. But you cannot go by any direction or any instruction of the district election officer or maybe chief electoral officer or even by some officer in the election commission. You have to apply your independent mind. And wherever some objection is raised, you have to give a reasoned order, because that is subject to question, and in the election petition that can be ground for questioning the election. So you must record your reasons. Starting with scrutiny proceedings, the date of scrutiny, as I have said, is already specified in the election commission's notification. You can't change it. Supposing some situation arises where on a particular day the election commission specified a day as the date of scrutiny, and then later on that is declared as a public holiday, then you need not be worried about this. We will take care of that situation, and the election commission will issue the revised notification fixing the next day. So on your own you cannot postpone. And then, as I have said, that you have already fixed the time for the scrutiny and also the place So don't change that place and time, otherwise people will allege that you gave us this place and you started the proceedings somewhere else, and so the scrutiny was done at our back, or you gave us the time at 11 o'clock, you started at 10. So don't change those dates and times and place also.